The courtroom was so quiet, I could hear the faint hum of the air conditioner above the judge's bench. Across the room, the 5 members of the Willow Creek Estates Homeowners Association board sat shoulder to shoulder, dressed in expensive suits that suddenly looked far less impressive than they had when this nightmare began. Their attorney had stopped taking notes. He simply stared at the stack of exhibits in front of him, as though hoping one of them would somehow disappear. I stood beside my lawyer, my palms damp despite months of preparation. 35 years. 35 years of paying my own taxes. 35 years of maintaining my own driveway. 35 years of never receiving a single HOA bill, attending a single HOA meeting, signing a single HOA document, or asking the association for anything. Yet somehow, according to them, I had supposedly been a mandatory member all along. The judge slowly adjusted his glasses and looked down at the newest piece of evidence my attorney had just handed to the bailiff. He read the first page, then the second, then the third. His eyebrows climbed higher with every sentence. Across the aisle, HOA President Rebecca Holloway shifted nervously in her chair. For the first time since I'd met her, she wasn't smiling. She wasn't whispering instructions to her attorney. She wasn't glaring at me. She simply stared at the judge with growing panic. My attorney, Daniel Mercer, remained perfectly calm. "Your Honor," he said, "would you please read the highlighted paragraph aloud for the record?" The judge looked over the top of his glasses. "You really want me to?" "Yes, Your Honor." A strange smile began tugging at the corners of the judge's mouth. He cleared his throat. Then he started reading. "The parcel identified as Lot 14B was intentionally excluded from the declaration of covenants, conditions, and restrictions due to the owner's refusal to participate, and because the developer had no legal authority to compel inclusion after the subdivision plat was finalized." Silence. Absolute silence. Rebecca's attorney froze. One board member quietly muttered, "No." The judge continued, "Future homeowners associations shall possess no authority over said parcel, unless a future owner voluntarily executes a separate written agreement." He stopped reading, removed his glasses, looked directly at Rebecca, then at her attorney, then at me. For several long seconds, nobody moved. Finally, the judge leaned back in his chair. A short chuckle escaped him. He tried to suppress it, failed. Another laugh followed. Soon the entire courtroom heard something none of us expected from a federal judge. He laughed, not loudly, not mockingly, just the kind of genuine, disbelieving laugh someone makes after realizing an argument is so absurd it shouldn't have made it into court in the first place. Rebecca's face drained of color. Her attorney slowly lowered his head into his hands. One juror exchanged confused looks with another before the judge reminded them to ignore his reaction and focus only on the evidence. The courtroom regained its composure. The judge wiped his eyes. "I've presided over property disputes for nearly 22 years, he said carefully. "But I must admit, this may be one of the most extraordinary documents I've ever seen." Rebecca suddenly stood. "Your Honor." "Sit down, Miss Holloway." She hesitated. "I said sit down." She collapsed back into her chair. The confidence she'd carried for months had vanished. I should have felt victorious. Instead, my stomach twisted into knots. Because none of this explained why the HOA had waited 35 years to come after me. None of it explained why they'd spent nearly $200,000 trying to force me into an association that had never governed my property. And it definitely didn't explain the anonymous phone call I'd received 3 nights before trial. The one voice I still couldn't identify. The one sentence I hadn't told anyone. If the judge sees the original files, Rebecca won't be the only one going to prison. As I looked toward the gallery, my eyes landed on a man I'd never seen before. He was sitting alone in the back row, watching me. The moment our eyes met, he quietly stood up and walked out of the courtroom before anyone noticed he was there. 3 months earlier, if someone had told me that a neighborhood homeowners association would drag me into a courtroom after ignoring my property for 35 years, I would have laughed just as hard as the judge eventually did. My name is Michael Turner. I'm 63 years old, a recently semi-retired civil engineer, and I've spent my entire adult life solving problems that other people considered impossible. Bridges, drainage systems, municipal roads. I built a career on reading blueprints carefully because one overlooked line on a map could cost millions of dollars. Ironically, it was an overlooked line on another map that nearly cost me my home. My property sat just outside Willow Creek Estates, a quiet neighborhood on the outskirts of Franklin, Tennessee, where rolling hills met old oak trees and neighbors still waved from their front porches. At least they used to. The land itself had belonged to my family long before there was a subdivision. My father bought the 12-acre parcel in 1971, back when the surrounding fields were mostly pasture. He built our farmhouse with his own hands, laying every brick after finishing long shifts at the county highway department. My mother planted the maple trees that now shaded the driveway. I learned to ride a bicycle on the gravel lane leading to the old barn. Every inch of that property carried memories. When Dad passed away, I inherited the land. When Mom died 6 years later, I promised myself I would never sell it. Developers called constantly. Some offered $1 million, others offered more. I thanked them politely and hung up every single time. Money couldn't replace a lifetime. Over the decades, neighborhoods slowly surrounded my property. Shopping centers appeared, schools were built, traffic increased. Eventually, a large subdivision called Willow Creek Estates rose on what had once been cattle fields bordering my eastern fence. I watched the houses go up one after another. Families moved in. Children rode bicycles past my mailbox. People assumed I lived inside the subdivision because my driveway connected to the same county road. But legally, my property had never been part of it. Not once in 35 years had anyone from the HOA contacted me. No welcome packet, no dues, no violation letters, nothing. Honestly, I appreciated the silence. I kept my place immaculate anyway. The white farmhouse stayed freshly painted. The fences remained straight. The grass was cut every Saturday morning. My workshop behind the barn became my favorite place in the world, filled with woodworking tools and old engineering drawings I'd collected over 4 decades. Most mornings followed the same peaceful routine. Coffee before sunrise. A slow walk around the property with my Labrador, Duke, checking the vegetable garden. Then spending a few hours restoring antique furniture in the workshop. It wasn't exciting, but after a lifetime of deadlines and construction projects, peace felt like luxury. My closest neighbor was Harold Benson, a retired Air Force mechanic in his 70s who lived just beyond my western property line. Unlike most people these days, Harold believed conversation should happen face-to-face instead of through text messages. Every afternoon around 4, he'd drive over in his battered pickup truck, carrying 2 iced teas. We'd sit on my porch discussing everything from baseball to politics to whose tomatoes were growing faster. One Tuesday afternoon, Harold arrived looking unusually serious. Instead of climbing onto the porch, he stood beside his truck with his hands shoved into his pockets. "You got company this morning?" he asked. I frowned. "What do you mean?" "Saw a black SUV parked at your gate around 9. I wasn't home. They were taking pictures. That caught my attention." "Pictures of what?" He shrugged. "Everything. My fences, the mailbox, the barn. They even measured something near your driveway." I laughed. "Probably county inspectors." Harold didn't laugh back. "They weren't driving county vehicles." That evening, curiosity got the better of me. I checked the security cameras I'd installed after a rash of equipment thefts in the area. Sure enough, at exactly 9:14 a.m., a black luxury SUV pulled up outside my entrance. 3 people climbed out. A woman in a navy blazer pointed toward my house, while speaking to 2 men carrying clipboards. One of the men stretched a measuring wheel down the edge of my driveway. The other photographed my mailbox, fence posts, and the stone monument displaying our family name. Turner Farm, East 1974. Then the woman walked directly to my locked front gate. She tried the handle, found it locked, looked straight into one of my security cameras and smiled. Not a friendly smile, the kind that says, "We'll be back." The next morning I found a large manila envelope tucked inside my mailbox. No postage, no return address. Inside was a single letter printed on expensive stationery. The heading read, "Willow Creek Estates Homeowners Association." The first sentence made me read it twice. "Our records indicate that your property has been in continuous violation of HOA membership obligations for the past 35 years. I actually laughed out loud. By the time I reached the final page, I wasn't laughing anymore. They were demanding over $428,000 in back dues, late fees, penalties, interest, and legal costs. At the bottom, in bold letters, was one final warning. Break to comply may result in a lien against your property and possible foreclosure. I stared at the letter for a long time. Then I looked out the kitchen window. Across the road, That same black SUV was parked beneath an oak tree. Someone inside was watching my house. I didn't panic. After 40 years as a civil engineer, I'd learned that the fastest way to make a bad situation worse was to react before understanding it. So instead of calling the number printed on the letter, I made coffee, sat at my kitchen table, and read every page again. The demand looked official enough to scare anyone who didn't know better. There were references to mandatory assessments, governing covenants, collection authority, and property enforcement. Every paragraph quoted legal language that sounded intimidating, but one thing immediately stood out. There wasn't a single document proving I'd ever agreed to join the HOA. Not one signature, not one deed reference, not one recorded covenant attached to my property. I folded the letter neatly, slipped it back into the envelope, and drove to the Williamson County Register of Deeds office. 3 hours later, I walked out carrying certified copies of every deed connected to my property, dating back to my father's purchase in 1971. Just as I'd remembered. Nothing. No HOA restrictions, no declarations, no amendments, no annexation agreements. Legally, my land appeared exactly as it always had, an independent parcel outside Willow Creek Estates. Either somebody made a mistake, I muttered to myself as I climbed into my truck, or somebody's counting on me not checking. The answer came 2 days later. Saturday morning was usually my favorite time of the week. I was halfway through repairing an old oak rocking chair in my workshop when Duke started barking. Not his normal bark. This one was sharp, protective. I stepped outside. 3 vehicles were parked at the end of my driveway. The same black SUV, a white pickup with the HOA logo on the door, and a luxury sedan I'd never seen before. 5 people stood outside my locked gate. The woman from the security footage stepped forward the moment she saw me. She looked to be in her early 50s, with perfectly styled blonde hair, designer sunglasses, and the kind of confident smile that suggested she wasn't used to hearing the word no. She pressed a button, and the gate intercom buzzed. I answered without opening it. "Can I help you?" She smiled wider. "You must be Mr. Turner." "I must be. I'm Rebecca Holloway, president of the Willow Creek Estates Homeowners Association." I figured. "We're here to discuss your outstanding balance." "I don't have one." She laughed softly as though I'd told a harmless joke. "Oh, Mr. Turner, that's exactly the misunderstanding we're here to clear up." I crossed my arms. "My property isn't in your HOA." "It absolutely is." "No, it isn't." Rebecca glanced toward the man beside her, who immediately opened a thick binder. "We have records." "So do I. Our records are current. My deeds are recorded with the county." For just a second, her smile faltered. Then it returned. "I'm sure this won't take long." "It already has." She ignored the comment. "If you'll simply open the gate, we'd like to inspect the property." "No." Her eyebrows lifted. "I'm sorry?" I said no. "We have authority to conduct compliance inspections. You have authority over your members. I am not one of them." One of the men behind her stepped forward. Tall, broad shoulders, arms folded across his chest. "We're trying to be reasonable here," he said. "So am I." Rebecca removed her sunglasses. Her expression had changed completely. The pleasant smile was gone. "Mr. Turner," she said evenly, "you're making a very expensive mistake." "No," I replied. "I think someone else already made one." She reached into her folder and held up another document. "This is your final notice." I already received one. "If payment isn't received within 10 business days, the association will record a lien against your property. You can't place a lien on land you don't control. We'll let the court decide that." I couldn't help smiling. "Please do." Her jaw tightened. Behind me, Duke growled low in his throat. Rebecca looked past me toward the barn. "Beautiful property." "It is. It would be a shame if legal fees forced you to sell it." The words hung in the air. Not a warning, a threat. Before I could answer, another voice interrupted. "What the hell's going on here?" Harold Benson's old pickup rolled to a stop beside my mailbox. He climbed out carrying the same wrench he'd apparently forgotten to put down after working on his truck. Harold wasn't a violent man, but he had the posture of someone who'd spent 26 years fixing military aircraft under impossible deadlines. Rebecca forced another smile. "This is official HOA business." Harold looked at her, then at me. "Mike ain't in your HOA." "We disagree," Harold chuckled. "County's been disagreeing with you since before half these houses were built." Rebecca's face hardened. "Sir, I'd advise you not to interfere." I'd advise you to get off his property. We're standing on public right-of-way.
Then keep standing there.
The tension was thick enough to feel. Neighbors had started gathering. Curtains moved. Garage doors opened. People watched from driveways, whispering among themselves. Rebecca seemed to notice. Without another word, she turned to one of the men. "Go ahead." He pulled a bright orange notice from his clipboard and stapled it directly to my wooden gate. Then another employee walked over to my mailbox and attached a fluorescent sticker reading, "Property under HOA enforcement action." I felt my blood boil. "You don't have permission to put anything on my property." Rebecca smiled again. "We just did." She climbed into the SUV. Before closing the door, she leaned out the window. "Oh, one more thing." "What?" "You might want to answer your phone. My attorney will be calling." I frowned. "I don't have an attorney." Her smile grew even colder. "You will." The convoy pulled away, leaving the orange notice fluttering against my gate. Harold walked over and tore it down before the vehicles disappeared around the corner. Neither of us spoke for nearly a minute. Finally, he looked at me. "Mike." "Yeah? I've lived next to you for 30 years. I've seen some crazy things, but this..." He shook his head slowly. "This isn't about HOA dues." I looked down at the notice in my hands. "I know." He lowered his voice. "I think somebody wants your land." And for the first time since this nightmare had begun, I realized he was probably right. Harold's words echoed in my mind, long after his pickup disappeared down the road. "I think somebody wants your land." At first, it sounded paranoid. By the following Monday, it sounded like the only explanation that made any sense. I wasn't worried about the money they demanded. I was worried about why they were demanding it now. 35 years of complete silence. Then, almost overnight, they were threatening foreclosure over an HOA that had never acknowledged my existence. People don't spend hundreds of thousands of dollars on attorneys unless they expect something much more valuable in return. I decided it was time to stop handling this alone. That afternoon, I drove to downtown Franklin and walked into the office of Daniel Mercer, one of the most respected real estate litigation attorneys in Middle Tennessee. His receptionist smiled politely. "Do you have an appointment?" "I don't." She gave me the sympathetic look reserved for people expecting miracles. "I'm afraid Mr. Mercer is booked for weeks." I slid the thick envelope from the HOA across the counter. "I think he'll want to see this." She glanced at the first page. Her expression changed immediately. "One moment." Less than 5 minutes later, I was sitting across from Daniel Mercer. He was in his late 50s, calm, sharply dressed, and had the habit of reading documents without saying a single word. He finished the demand letter, read it again, then looked at me. "You've never paid HOA dues?" "Never." "You've never signed membership papers?" "No." "You've never attended a meeting?" "I've never even been invited." He nodded slowly. "Interesting." I handed him the certified copies of every deed I'd collected from the county. He spread them across his conference table. For nearly 20 minutes, he compared legal descriptions, parcel numbers, subdivision plats, and recorded covenants. The room stayed silent except for the rustling of paper. Finally, he leaned back. "I have good news." I raised an eyebrow. "And bad news?" "The good news is your property isn't covered by any recorded HOA declaration." I let out a slow breath. "The bad?" "They know that." I stared at him. "What makes you so sure?" Daniel tapped the demand letter. "Because no competent attorney would file this unless someone deliberately omitted these county records." "You think it's intentional?" "I think somebody expected you to panic and settle before hiring counsel." He reached for his phone. "I'm going to order the complete development file. The county already gave me my deeds." "I'm not talking about deeds." "What then?" "The subdivision approval records, the developer's correspondence, planning commission files, original plats, annexation requests, construction permits." Sometimes the most important documents never appear in property records. That afternoon, his legal assistant began filing requests with the county planning office, zoning commission, and archives. Meanwhile, Daniel asked me a question I hadn't considered. "Has anyone offered to buy your land recently?" I laughed. "Developers ask every year." "Recently?" I thought for a moment. "Actually, yes. About 6 months ago." "Tell me." "A man named Victor Langford." Daniel's pen stopped moving. "Langford Development Group?" "I think so. He offered almost $3 million. And?" I said no. Daniel looked thoughtful. Did he seem disappointed? He smiled. Said I'd change my mind eventually. Daniel didn't smile back. I've sued Langford Development twice. That got my attention. They don't like hearing the word no. Before I could ask another question, his assistant hurried into the office carrying a folder. Daniel, you need to see this. She laid several freshly printed documents on the table. The first was an aerial planning map. Daniel pointed at my property. Notice anything? I studied it. At first, nothing. Then I realized every road inside Willow Creek Estates curved around my land like water flowing around a rock. It looks... Interrupted, Daniel finished. He placed another map beside it. This one showed a proposed expansion. A thick red line ran directly across my property. What am I looking at? A preliminary concept plan submitted 18 months ago. For what? He slid the document closer. I read the title. Willow Creek Estates, Phase 4, Proposed Gated Expansion. My stomach tightened. The proposed entrance road, the community clubhouse, the visitor parking lot, even the decorative lake. Every major feature was planned exactly where my farmhouse, barn, workshop, and garden stood. I looked up. They designed the expansion through my property. Daniel nodded. They certainly did. But they don't own it. No. So why spend money designing something impossible? Daniel didn't answer immediately. Instead, he reached for another document. This was filed the same week. It was an internal memorandum obtained through a public records request. Most of it discussed infrastructure, budget estimates, traffic studies. Then one sentence near the bottom caught my eye. Acquisition of Parcel 14B remains the only unresolved obstacle before construction may proceed. Parcel 14B. That was my land. Daniel folded his hands. They've known for at least 18 months that your property stood in the way. I felt a chill run down my spine. So the HOA may not be acting alone. Just then, his assistant spoke again. There's one more thing. She handed Daniel a photocopy of an old Planning Commission attendance sheet from 1991. He scanned the names, then slowly turned the page toward me. There, halfway down the list, were two signatures side by side, Rebecca Holloway and Victor Langford. Next to both names was the same handwritten note, Committee for Future Annexation Strategy. Daniel looked me straight in the eyes. Mr. Turner, I don't think this started with Rebecca. I think you've just uncovered a plan that's been waiting more than 3 decades. I sat in Daniel Mercer's office, staring at the signatures on that 35-year-old attendance sheet. Rebecca Holloway, Victor Langford. 2 names I'd assumed had crossed paths only recently. Instead, they had apparently been working toward the same goal since the early 1990s. Daniel closed the folder carefully. This changes the case. How? Until now, he said, we were defending you against an HOA trying to collect dues. He pointed at the expansion map. Now we're proving motive. Motive? They don't want your membership. They want your land. For the first time since this ordeal began, the puzzle pieces actually started fitting together. The sudden HOA demands, the outrageous claim for 35 years of back dues, the threats of foreclosure, the inspections, the surveillance. It had never been about neighborhood rules. If they could bury me under enough legal pressure, force a lien onto my property, or convince a judge that I owed hundreds of thousands of dollars, they hoped I'd do what countless exhausted homeowners had done before me. Sell. Daniel leaned back in his chair. But motive alone won't win this case. What will? Proof. The next 4 days became a whirlwind. Daniel's legal team issued subpoenas, requested archived county files, and interviewed retired county employees who had worked on the original Willow Creek Estates development. Every evening I returned home mentally exhausted, wondering what fresh surprise awaited me the next morning. On Thursday afternoon, Daniel called. Can you come in? His voice sounded different, calmer than usual. Whenever an experienced attorney became that calm, it usually meant something significant had happened. 20 minutes later, I walked into his conference room. A woman I'd never met stood beside the table. She looked to be in her late 70s, dressed simply, with silver hair pulled neatly into a bun. Daniel smiled. "Mike, I'd like you to meet Eleanor Brooks." She extended her hand. "It's nice to finally meet the man living on parcel 14B. You know my property?" A faint smile crossed her face. "I should. I drew the original subdivision plats." I blinked. "You were the county surveyor." "The assistant county surveyor," she corrected. "Back then, everything was done by hand." She opened a weathered leather tube and carefully removed several oversized survey sheets. Unlike the photocopies we'd seen before, these were originals. The paper had yellowed with age, but the ink remained remarkably clear. She spread one across the conference table. "This," she said softly, "is the map that was actually approved." Daniel pointed toward my property. "Notice anything?" I leaned closer. A bold, handwritten note appeared beside my parcel. "Exclusived by owner request. No HOA jurisdiction." My heart skipped. Eleanor nodded. "Your father refused to join the planned association." I remember that. He argued that his farm existed decades before the subdivision. He wasn't interested in community amenities or architectural rules, so the developer agreed. They had no choice. She tapped the note with one finger. "County approval required your parcel to remain independent." I frowned. "Then how did all this happen?" Eleanor sighed. "Because somebody changed history." Daniel opened another folder. Inside were two nearly identical subdivision plats. At first glance, they looked the same. Then he placed them side by side. The differences became obvious. On the original survey, my parcel was outlined in blue. On the recorded version submitted years later, the blue outline had disappeared. Even more disturbing, the handwritten exclusion note was gone. Someone had created a cleaned-up copy, not an obvious forgery. Just edited. "So which one is legal?" I asked. Daniel answered immediately. "The signed original. The altered copy has no approval initials." Eleanor nodded. "And whoever removed that note never expected the originals to survive." The room fell silent. Finally, Daniel slid one last document toward me. "I think you'll appreciate this." It was an email obtained through discovery after the HOA filed suit. The sender was Victor Langford, the recipient Rebecca Holloway. The subject line read, "Parcel 14B." I began reading. "If Turner continues refusing our purchase offers, HOA enforcement gives us the leverage we need. Once legal expenses start piling up, he'll eventually accept a settlement. Keep pressing the membership issue until he's boxed in." I looked up slowly. "They actually wrote that?" Daniel nodded. "In black and white." Before I could respond, my phone buzzed. Unknown number. Normally, I ignored unknown calls. This time I answered. Michael Turner. Several seconds of silence, then a man's voice. Calm, controlled. "You've made this much harder than it needed to be." "Who is this?" "You've already been offered more money than that property is worth." "My home isn't for sale." A quiet laugh came through the speaker. "Everyone has a price. Not me." His tone hardened instantly. "You should think about your family." Every muscle in my body tightened. "What did you say?" "It'd be unfortunate if someone got hurt because of an old farmhouse." The line went dead. Daniel had heard enough of the conversation to recognize the expression on my face. "What happened?" I lowered the phone. That wasn't a negotiation. No. It was a threat. Daniel immediately reached for his desk phone. "I'm calling the sheriff." As he dialed, his assistant rushed into the conference room, visibly shaken. "Daniel." He looked up. "What now?" "The HOA just filed an emergency motion." "What kind of motion?" She swallowed hard. "They're asking the court for immediate authority to place a lien on Mr. Turner's property before the trial even begins." Daniel stood so quickly his chair rolled backward into the wall. "They're panicking." I stared at the email, then at the original survey map lying on the table. For the first time, we had the evidence to expose the entire scheme. Now we just had to convince the court before they found another way to take my home. The Williamson County Courthouse had never felt smaller. By 8:30 that morning, every seat in the gallery was occupied. Neighbors from Willow Creek Estates filled the back rows. Several county officials sat together near the aisle, quietly reviewing folders. Two local reporters whispered to one another while setting up notebooks. Even Harold had arrived nearly an hour early, wearing the only suit I'd ever seen him own. He caught my eye across the room. "You ready?" he asked. I managed a nervous smile. "As ready as I'll ever be." He squeezed my shoulder. Truth's on your side. I hope that's enough. Before I could say another word, the courtroom doors opened. Rebecca Holloway entered with Victor Langford walking beside her. It was the first time I'd seen them together. Victor looked exactly like the kind of developer who believed every piece of land eventually belonged to the highest bidder. Expensive navy suit, silver watch that probably cost more than my pickup truck, perfectly polished shoes. He smiled as if today's hearing was simply another business meeting. Rebecca, on the other hand, looked exhausted. Dark circles rested beneath her eyes. She avoided looking at me. Instead, she whispered something to her attorney before taking her seat. Daniel leaned toward me. See that? What? They're sitting together. So? So the HOA is supposed to represent homeowners. He nodded toward Victor. Not private developers. The bailiff stood. All rise. Everyone rose as Judge Samuel Whitaker entered the courtroom. He settled into his chair, adjusted the files in front of him, and looked over the packed gallery. This matter concerns Willow Creek Estates Homeowners Association versus Michael Turner. He paused. I understand this case has generated considerable public interest. His eyes swept across the room. That interest will remain outside this courtroom. No outbursts, no commentary, no interruptions. Understood. A chorus of quiet, "Yes, Your Honor," filled the room. Very well. He nodded toward the HOA's attorney. You may proceed. The attorney stood confidently. Your Honor, this case is straightforward. He walked slowly before the jury. The defendant has enjoyed the benefits of Willow Creek Estates for decades, while refusing to contribute financially. Daniel scribbled something on his legal pad. The attorney continued. He has used community roads. Daniel immediately stood. Objection. Judge Whitaker looked up. Basis? There are no HOA-owned roads leading to my client's property. The judge looked toward the HOA attorney. Is that statement accurate? The attorney hesitated. The roads are county-maintained. So your first statement was incorrect. It was imprecise. Sustained. The attorney cleared his throat and continued. The defendant's property has always been intended as part of the development. Daniel remained seated but quietly whispered to me. Listen carefully. The attorney projected a subdivision plat onto a large courtroom screen. There, Your Honor, he pointed confidently. Parcel 14B. Our records clearly place it within the association. Judge Whitaker nodded. Mr. Mercer? Daniel stood without haste. No questions yet, Your Honor. I'd simply like the witness to identify the source of that map. The attorney frowned. It comes from HOA archives. Daniel smiled politely. No county approval stamp? No. No surveyor certification? No. No planning commission signatures? No. Silence. Daniel returned to his table. I'll address it later. The HOA called Rebecca Holloway as its first witness. She walked to the stand with practiced confidence. After taking the oath, she folded her hands neatly. The attorney smiled. Ms. Holloway, has the association always considered Mr. Turner's property part of Willow Creek Estates? Yes. And has he ever paid required assessments? No. Did the association attempt to resolve this privately? Repeatedly. She looked toward the jury with an expression that almost resembled sympathy. We tried everything before filing suit. Daniel stood. Cross-examination. He approached slowly. Good morning, Ms. Holloway. Good morning. You've served as HOA president for 11 years. Yes. You've reviewed association records personally. I have. You testified your board always considered my client's property part of the HOA. Correct. Daniel picked up a binder. Would you agree honesty is important under oath? Of course. He opened the binder. I'm showing you Exhibit 27. She glanced down. What is it? Minutes from the HOA board meeting held on April 16th, 5 years ago. She looked uncomfortable. I don't remember every meeting. I'll refresh your memory, Daniel read aloud. Board discussion acknowledged that Parcel 14B remains outside HOA authority unless ownership changes. Rebecca froze. The courtroom became noticeably quieter. Daniel looked up. Did I read that correctly? She swallowed. Yes. So 5 years ago, you acknowledged Mr. Turner's property was outside HOA authority. She shifted in her chair. That was based on incomplete information. Daniel reached for another document. What about this? He handed it to the bailiff. The document made its way to Rebecca. Her face changed immediately. She recognized it before anyone said a word. Daniel spoke softly. That's an email you sent to Victor Langford 18 months ago. The jury watched her carefully. He continued. In the second paragraph you wrote, he read directly from the page. Once we establish HOA jurisdiction, Turner won't have many options left. Rebecca's lips parted. Daniel interrupted gently. Is that your email? Her attorney stood. Objection. Answer the question, Judge Whitaker said firmly. Rebecca stared at the paper for several long seconds. Then, almost inaudibly, yes. Daniel nodded once. No further questions. As Rebecca stepped down from the witness stand, she refused to look at Victor Langford. Instead, she stared at the floor. Victor's confident smile had vanished. For the first time all morning, he leaned toward his attorney and whispered urgently. The attorney's face tightened. Judge Whitaker noticed. Then he turned toward Daniel. Mr. Mercer, I believe you indicated you intended to call the original county surveyor. Daniel smiled. Yes, Your Honor. We do. Eleanor Brooks slowly stood from the front row and walked toward the witness stand, carrying a long leather document tube. Inside it was the original survey that had remained hidden for 35 years. Eleanor Brooks moved with the steady confidence of someone who had spent an entire career knowing that accuracy mattered more than speed. She placed the weathered leather tube on the witness stand and carefully removed the rolled survey. The paper looked fragile. 35 years of age had yellowed its edges, but every line remained sharp. Every signature was intact. Every approval stamp was clearly visible. Daniel Mercer smiled politely. Mrs. Brooks, would you please tell the court your occupation before retirement? I served as assistant county surveyor for Williamson County for 28 years. Were you involved in the approval of Willow Creek Estates? I was. Did you prepare this document? I did. Daniel held up the original survey for the courtroom to see. Is this the original approved subdivision plat? It is. And has it been altered in any way since county approval? No, he nodded. Could you direct the court's attention to parcel 14B? She pointed to my property. Then, using a wooden pointer, she tapped the handwritten note beside it. Excluded by owner request. No HOA jurisdiction. Her voice was calm. This notation was written by me during the final approval meeting. Daniel asked why. Because Mr. Richard Turner, she smiled toward me, Michael's father refused to place his farm under HOA authority. Could the developer force him? No. Could the county? No. Could a future homeowners association? She looked directly at the judge. Absolutely not. The courtroom fell silent. Daniel took one step closer. So from the day this subdivision was approved, my client's property has never been subject to the HOA. Correct. No exceptions? None. Daniel smiled. No further questions. The HOA attorney stood for cross-examination, but the confidence he'd shown that morning had disappeared. Mrs. Brooks, isn't it possible that later amendments changed the property's status? She answered immediately. Only if the owner voluntarily signed them. Did he? No. Do you know that for certain? I checked before coming here. She reached into her folder and produced certified county records. There are no recorded annexation agreements. The attorney glanced at the documents, then quietly sat down. I have no further questions. Daniel wasn't finished. Your Honor, he said, the defense requests permission to publish Defendant's Exhibit 41. Granted. The courtroom screen lit up. It wasn't another map. It was Victor Langford's email. Every word appeared in large letters for the jury and gallery to read. If Turner continues refusing our purchase offers, HOA enforcement gives us the leverage we need. Once legal expenses start piling up, he'll eventually accept a settlement. Keep pressing the membership issue until he's boxed in. Gasps echoed through the courtroom. Someone in the gallery whispered, "You've got to be kidding me." Judge Whitaker looked over his glasses. Order! The room fell quiet again. Daniel turned toward Victor Langford. Mr. Langford, would you please stand? Victor hesitated. His attorney whispered frantically. Judge Whitaker's voice cut through the courtroom. Mr. Langford. He slowly stood. Daniel held up the printed email. Did you write this? Victor shifted his weight. I don't recall. Daniel handed another document to the bailiff. This is the server authentication log from your company's email provider. It confirms the message originated from your office computer. Victor's shoulders sagged. Yes. And you instructed the HOA to pressure Mr. Turner into selling his property. It wasn't like that. Daniel raised an eyebrow. No? Victor cleared his throat. We believe the property should be integrated into the community. So you attempted to manufacture HOA authority that didn't legally exist. No. You merely hoped Mr. Turner would believe it existed? Victor said nothing. Daniel waited. The silence became unbearable. Finally, yes. You could almost feel the air leave the room. Rebecca Holloway closed her eyes. She didn't even try to defend herself anymore. Judge Whittaker folded his hands. I believe I've heard enough. The courtroom became so still that even the reporters stopped typing. The judge reviewed his notes for several minutes. When he finally looked up, his expression was firm. The evidence in this matter is overwhelming. He turned toward the HOA board. The court finds that Parcel 14B has never been subject to the Willow Creek Estates Homeowners Association. He paused. Therefore, every assessment, lien threat, demand letter, and enforcement action against Mr. Turner was without legal authority. Rebecca lowered her head. Judge Whittaker continued, "The association's complaint is dismissed with prejudice." A quiet murmur spread through the gallery. He wasn't finished. The court further finds compelling evidence that this litigation was initiated in bad faith as part of an effort to pressure Mr. Turner into relinquishing property needed for a private development. Victor's attorney stood. "Your Honor, sit down." His voice was calm but final. "I will also refer this matter to the district attorney for review of possible fraud, document alteration, abuse of legal process, and any other violations supported by the evidence." Rebecca's face turned pale. Victor stared straight ahead. Neither of them spoke. Judge Whittaker looked toward me. "Mr. Turner," I stood. "I understand this lawsuit has consumed nearly a year of your life." "Yes, Your Honor." "You should never have been forced to defend rights that were already guaranteed by law." Then, with the faint smile that had become famous among everyone in that courtroom, he added, "And I sincerely hope no one ever again waits 35 years to discover they have absolutely no authority over your property." Soft laughter rippled through the courtroom. Even the bailiff smiled. The tension that had lived inside my chest for months finally disappeared. Harold slapped me on the back so hard I nearly stumbled. "I told you," he grinned, his eyes watering. Truth was enough. Outside the courthouse, reporters crowded the front steps. Cameras flashed as neighbors applauded. Several Willow Creek residents walked over, not to defend the HOA, but to apologize. One elderly woman shook my hand. "We trusted the board," she said quietly. "We had no idea what they were doing." I nodded. "I know." Within weeks, the HOA board resigned under mounting pressure from homeowners. The association elected an entirely new board, hired independent auditors, and began reviewing years of financial records. As for Victor Langford, the county suspended consideration of his proposed Phase 4 expansion while investigators examined the evidence presented at trial. For the first time in months, I drove home without wondering if another threatening letter would be waiting in my mailbox. When I turned onto my gravel driveway, the afternoon sun lit up the old farmhouse my father had built. It was still standing, exactly where it belonged. And this time, everyone finally knew why. These days, life has finally returned to the way I always wanted it to be. Quiet. Every morning, I still pour a cup of coffee before sunrise and walk the property with Duke. The maple trees my mother planted continue to cast their shade across the driveway, and my father's old barn still stands proudly against the Tennessee sky. The only difference now is that I no longer glance toward the road expecting another threatening letter or another black SUV pulling up to my gate. The land stayed exactly where it belonged, with the family that had cared for it for more than half a century. Looking back, I realized this fight was never really about an HOA. It was about knowing your rights and refusing to let fear make your decisions. There were moments when it would have been easier to give up, write a check, or simply sell the property and walk away. But if I had done that, I wouldn't have just lost my home. I would have surrendered the truth. One lesson has stayed with me through all of this. Never assume that someone with authority is actually right. Verify the facts, keep your records, and don't be afraid to stand your ground when the law is on your side. Sometimes the most powerful evidence is a piece of paper that's been sitting in a county archive for decades. If you've ever dealt with an HOA, a difficult neighbor, or a property dispute, I'd genuinely love to hear your story. Have you ever had to fight for something that was rightfully yours? Share your experience in the comments. I read as many as I can, and your story might encourage someone else who feels like they're fighting alone. If you enjoyed this story, please like, subscribe, and turn on notifications so you never miss another real-style property rights and HOA drama. Thank you for spending your time with me today. Until next time, remember, the truth may take time to surface, but when it does, It has a way of speaking louder than anyone else ever could.